So here we are again on Perspectives on Closing Loopholes, one of a series of online offerings by Clayton Utz. This series has been created to help you navigate the raft of industrial relations changes in Australia. We've had some of the most amazing industrial minds in the country and to provide you different perspectives from our key stakeholders. So we'll discuss what the changes mean for employees, employers and the industrial relations systems. So we've had an incredible response to our guests to date. We kicked off the series with His Honour President Hatcher, the President of the Fair Work Commission, and then we heard from Professor Ron McCallum, AO, a leading legal academic, and he was joined with Dr Graham Smith, one of the sharpest industrial minds in the country. We then had leading IR Silk, Frank Parry KC, who had some fiery comments to say and was certainly a really interesting episode. So if you've not seen these episodes yet and you're interested, they're available on our Clayton Utz website or anywhere where you access your podcasts from. I'm Shay McCartney and I'm joined by my partner Matt Kelleher, and we're really pleased to present this series on behalf of our National Workplace Relations Employment and Safety team. Before we start, I'd like to acknowledge the Gadigal people of the Eora Nation, the traditional owners and custodians of the land on which we meet, and to pay respect to their connections to land, water and community. We recognise their ongoing strength and resilience and the important role they play as leaders in their communities. And I pay my respects to their elders past, present and emerging. Matt, I'll get to you to introduce our esteemed guest today.
Thanks, Shay, and thanks to our viewers for joining. Today we have the privilege of speaking with Jessica Tinsley, the Director of Workplace Relations and General Counsel of the Australian Chamber of Commerce and Industry. ACCI is Australia's largest and most representative business network that represents Australian businesses of all shapes and sizes across many sectors of the economy. Before joining ACCI, Jessica practiced as an employment lawyer and was then an advisor to the former Commonwealth Attorney General and Minister for Industrial Relations. In her role at ACCI, Jess leads ACCI's policy and advocacy work in industrial relations, regularly appears before the Fair Work Commission and represents employers in test cases on the application of the Fair Work Act, and has had the good fortune of representing Australian businesses internationally and at bodies such as the International Labour Organisation. Jess, it's great to have you here today, and we're thrilled to hear your perspectives, largely from an employer's side, to discuss some of these complicated IR reforms that the country is facing.
Esteemed guest, I'm very privileged to hear that. Thank you, team.
So Jess, can we start off with, we know ACCI played an integral role, particularly for businesses in navigating the proposed IR reforms since Labor won the election in 2022. And ACCI was heavily involved in consulting with its members, meeting with the government and opposition and lobbying with the crossbench ahead of the introduction of the reforms. Can you talk to us about some of your insights and, you know, the way you saw it playing out and particularly, your reflections on the momentous reforms that we've seen?
Yeah, absolutely. So I guess these reforms, changes, whatever we'd like to call them, they're incredibly significant and something that I've been thinking about for before the current government even came to power. So in my role as a industrial relations advisor to the former government, we know that the then Labor opposition took a lot of these policies, not all of them critically, but most of them to the former election. So I think in my years now, considering these topics, I think really probably two issues, two key themes, and this is a question that I'm often asked in terms of like, what is the government trying to do? We had the Secure Jobs Better Pay legislation, we had some additional sort of smaller bills go through, and now we've got closing loopholes number 1, closing loopholes number 2. I know we're all very exhausted from this process. But I think that the two key takeaways, not so much the purpose of the laws, but maybe probably twofold. So first of all, it's clear that the government really wants to put trade unions at the heart of the industrial relations system. So what I mean here is you talk...
Well, at least they did.
Yes. You talk to any member of the current government and it's clear they legitimately believe that terms and conditions should be negotiated between employers and not with the workforces directly, but through bargaining with the trade union. So I think that's critical. In terms of disputes or other issues that arise, there seems to be a genuineness and a real desire that those disputes should be resolved, again, not between the employer and the individual employee or the workforce, but again, that third-party interference there through the trade union movement, whether that's at the workplace level or also in the Commission. And we know that the big part of all these reforms is the addition of arbitration. So we know employers are going to find themselves spending more and more time within the Commission. And arbitration, it's not conciliation, it's complicated. Employees will need to be represented by union reps. So I think that is the first big takeaway that I think is a common theme throughout all the legislation. I think the second important one, and this really came through particularly with the Closing Loopholes Bill, is the strong preference that certainly the trade union movement has and the government has in terms of permanent employment. I think that the common theme, the key theme of both sets of Closing Loopholes Bill was essentially what I'd call almost a demonisation of flexible forms of work. So we saw a little taste of that in the Secure Jobs Better Pay legislation with restrictions on fixed term contracts. And then we've seen that through more recently through restrictions on the use of labour hire, through restrictions placed on casual employment, and restrictions through independent contracting. So I think the two big themes for this government in their industrial relations reforms, increased power for trade unions and at the Commission, and really the piece about the essentially demonisation of flexible forms of work.
And I'll ask you some questions specifically on the flexibility and whether that's consistent with the modern workforce in a while. But I'm really interested as to how your members see these changes and what's the feedback that you are getting from your members, I guess, through the process and now since some of them have come into play and some of them are about to come into play.
Well, I think the key issues that were identified early on are probably the same ones that we're seeing. I think they were obvious. Yeah, there were certainly obvious issues, and I think they're really playing out now. So the big picture item here is increased compliance costs. So here I'm not even talking about the desire of government to increase wages. That's not where we know that's not really where the compliance costs are arising from here. It's the uncertainty. So you look through the amount of additional multi-factor tests throughout all this legislation, the amount of discretion that's been given to the Fair Work Commission. It's this increased uncertainty and the need to engage lawyers such as yourselves to work through this complexity, signing up and being members of organisations like the Australian Chamber, our state and territory chambers, industry associations. It's working through these issues where we still had this uncertainty in before these changes. There was certainly it was by no means perfect, but there's so much that's unknown, and that drives up compliance costs. The other key issue that has always been identified and that I've already essentially touched on before was the amount of time that employers are going to spend in the Fair Work Commission. Again, we've got new laws around increase. We've got the compulsory arbitration within the bargaining framework. We've got arbitration in terms of the casual conversion. We've got arbitration for the flexible working arrangements, thinking back to the Secure Jobs Better Pay legislation. We've got the new right to disconnect jurisdiction that will operate in a similar way to the stop bullying jurisdiction. So all this means is more time for employers to be in the Commission, and when employers are in the Commission, they're not running their businesses. So I think that's the second really big point here. I think tied very much to that point is increased disputation. I think we've got, obviously if you're in the Commission, there's a dispute of some sort going on. It's not just, it's not a kumbaya situation. Often it is adversarial. We've also got increased rights for unions in terms of right of entry, delegates' rights. So when you increase the presence of unions on workforces, what we know from experience is that increases disputation. So I think that's also a big key issue. The final one I would really draw attention to is probably an obvious one as well. The feedback, despite all those three things, the biggest bit of feedback I've got is the pace of change.
Yeah,
it's extraordinary. I think you'd be hard pressed to find a single part of the Fair Work Act that is now unchanged, and we've got entirely new set of laws to get our head around. So,
and of course, it's not the only area that's changing, because you've then got, right to the Respect at Work changes, the WHS Act changes. Every area seems to be sort of changing at pace. Matt, it might be a good time to talk about a new set of changes being in the gig economy.
Yeah, the gig economy.
Hand over to you.
Thanks for that overview, Jess. The closing loopholes legislation advanced significant changes to the gig economy, introducing a new employee-like worker, establishing a jurisdiction in the Commission to regulate minimum terms and conditions of gig workers, and providing a new forum for these workers to challenge unfair deactivations. The Fair Work Commission will also soon have new powers to issue minimum standard orders for employee-like workers. Can you talk to us around how ACCI is communicating with its members around these gig economy changes and how the new employee-like worker definition will likely impact employer businesses?
So this is a key area of interest for me at the moment. We've got a lot of, and I won't name them, but we've got a lot of most of the big players in particularly the rideshare and food delivery space we've got as members. So very much front of mind.
I won't name them, but there's lots of jingles that I could sing.
Absolutely. So there's, in terms of the work that's going in, we know that the new laws will come into effect from the 26th of August. I believe it's 26th of August, so very soon. The grumblings are very much that the TWU is snooping around, that we're likely to see an application. Where it will be is to be seen, but we'll see an application very early on. So really the key there has been, and this isn't something that I've had to tell my members, but the preparation that's going into understanding what the business can afford in terms of the minimum standards. We know that we've got a list of things that the Commission can't make orders for, and that was welcome, things like overtime rates, etc. But then there's a non-exhaustive list of things like pay, record keeping, cost recovery, delegates' rights that are clearly on the table, that will have an enormous impact on businesses in the space. We know that this goes beyond just the gig economy as well, and I actually might come back to that a little bit later, but particularly the road transport. So we've got some of the big players in terms of the Australian Trucking Association, that road, that are helping their members as well in terms of preparing for the new federal road transport jurisdiction, which again will set minimum standards orders. But really, again, it's the preparation there, because if the experience of, say, let's think about the New South Wales owner-driver jurisdiction that we've had in place for a long time now, I think a key experience there has been that these orders are often sought by consent. Tribunals like to make these orders by consent. So we're unlikely, and I don't want to necessarily sort of, look into the crystal ball too much, but if that experience is reflected and all indications are there, is that there will be lots of behind the scenes conciliations, conferences, trying to get consensus. So we'd be predicting here a long drawn out process, but really sort of heading into those almost as a negotiation. What can I afford? What is, the other side, I guess, in terms of here, the TWU and potentially other unions as this jurisdiction evolves. What impacts will this have on my business? Because we know that when we go into that, we need to be armed with that economic arguments in terms of, remembering that these are minimum standards. I think it's just the preparation and critically being in it as well. So there's some big players that know they're going to be roped in.
Yeah.
But there's also all these other players. There's these players on the corners.
Even the strategy of whether you're better to be in or out, depending on what your competitors are doing. They're big decisions, aren't they?
Exactly. So that's for those that are, I guess, definitely in. Some of those figuring out whether you're in or out, and then remembering as well that the sort of these are quite consumer facing, or they are consumer facing sectors that are going to be hit through this. So the minister's already come out and said to expect more for the price of your pizza. Yep. So that's not just flow on impact for consumers, but also, let's say we're looking at food delivery, for instance. restaurants, the impact on restaurants, cafes. So we're not just talking to those sectors, those members in those sectors that are directly impacted, but it's trying to raise awareness in terms of that these will have quite broad-ranging effects.
How do you see it impacting the flexibility of independent contractors in the IR landscape?
It certainly will place restrictions on that flexibility, and I think that's very much the purpose of these laws in a way. By design, the government has kept these people as independent contractors, but they're really not. So the minister's always a little bit reluctant to call it a third way. But if we think about it, it is really a third way. We've got a group of, we've got independent contractors that really should be able to negotiate a commercial arrangement with the principal. We've got employees within the employment framework, and now we've got this in between where there will be certain things that will be left for the parties to negotiate between themselves, but then there's going to be a large chunk of standards that the Commission will determine. If you're involved in these proceedings, then you'll have a direct say. But noting as well, just because you're not a direct party to these proceedings, they can still impact you as well.
Completely different topic now, but you've spent a lot of time in Geneva recently, and I assume some of the discourse might have been about the right to disconnect. I think Matt's going to talk to you now about that and what you're seeing.
Yeah, the right to disconnect, Jess, obviously a very hotly discussed area. The Commission's just released its model term, so we thought an opportune time to hear your perspective around that as well. ACCI has already expressed, I would say, some contentment with the proposed term, stating that the Commission has adopted a light touch approach and did not deliver on union calls for a prescriptive term, imposing additional obligations and rights that are not required under the legislation itself. Is this a win for employers in terms of the model term? How does that alleviate some of the potential hesitations that employers held in relation to the right to disconnect, which seemed to come a little bit out of nowhere?
So it's probably a little bit to unpack there. I guess the right to disconnect is a...
You can object to the question if it's too multi-pronged.
No. I think I'll take a step back and just say I think the right to disconnect is it's probably a loss for common sense. Generally, the laws as a whole, but they've now law, so we have to, or they're about to be, they will commence soon. So we're obviously engaging in that fair work process to try and steer what that model term will look like that will fit into all modern awards. So we made submissions, we've met with the full bench as a peak council privately as well to push our views on this. And one of the key points that we did make through this process is we do want a light touch approach. And what we meant by that is essentially one that you can pick up and apply in various different workplaces, because we know what the right to disconnect might look like in one workplace is not going to be the same in a different sort of workplace. And that's true across sectors and industries and even within them as well, the way people work and cultural aspects there as well. So we were pleased to see that for the most part, the provisions don't go further than what's required in the legislation. I think an interesting point there, the one bit we're providing sort of bits and pieces of feedback on this, because noting as well, it hasn't been finalised yet. This was just the Commission's provisional view that we were generally...
They've still got to receive the union's feedback
exactly.
on it as well. Yep.
So by the time this is released, who knows, maybe we will see a draft and I'll want to distance myself completely from it. But the provision is drafted at the moment, generally looks like it's just reflecting what's in the set out in the legislation, has ignored most of some of the crazy calls from the union movement, which really wanted to include so many additional restrictions on employers there. The one interesting point to keep an eye on, though, is one provision in the draft term says something along the lines of that an employer, it's the only part there that really puts a strong obligation or requirement on the employer to not directly or indirectly prevent someone from exercising their right to disconnect. Now, on its face, you'd just say, oh, well, that's essentially what the general protections provisions would cover. And I think that's probably what the provision, what the model draft clause is trying to do. But I'm a little bit concerned about potentially how broad that could be interpreted as. So, how would you directly or indirectly prevent So I think as a matter of a more technical point there is we would prefer, and this is a submission we will be making as part of this process, to essentially clarify that the right to disconnect is a workplace right and make sure that we're just fitting it in within the existing framework.
Do you think there's clarity or enough clarity around the reasonableness of an employee's refusal to respond to contact outside of hours, and concerns, I guess, that have been raised in professional services sectors that have inconsistent hours and employees being able to reasonably refuse in that space? Is there enough clarity around that?
Well, certainly not at this stage. We've got one, and the Commission has refused to sort of weigh in terms of what should be reasonable for the most part within the model term. To be fair, I think that's probably fair enough. You don't want to be imposing prescriptive, reasonable tests within the term that won't fit workplace to workplace. So I think on one hand, we do need to keep reasonableness a little bit flexible, or a little bit so it can be interpreted differently workplace to workplace. I guess when we start to see some of the test cases come through, that will be of assistance, because again, it's going back to this complexity point. There's so much uncertainty on how this will be interpreted. But no, I don't think there is that clarity at this stage. I think what I'm talking to members about at the moment to prepare for what's coming is really to make sure that we've got quite clear company-wide policies and procedures set out that say, within the context of this workplace, this is what we consider to be reasonable. That can be policy, and also probably even more preferably if you've got certain employees that are likely to work after hours every now and then for particular reasons, even having that in the contract first up, I think is useful.
And I think even just creating the systems around it. So, if people have a place to raise grievances or complaints or concerns about the level of, engagement, for example, after hours, then, they get resolved in that manner, and then, you show your reasonableness by the way you respond. Where I see it playing out is the work cover claims where, the employer didn't even know that this was going on until, it's already become a claim rather than being able to deal with it up front.
Well, I think that's how it's going to be used. I think the mischief here will be from those, and we all know these employees. It will be another tool in the arsenal of that employee, try and performance manage them, then suddenly you've got a bullying complaint, you've got a workers' comp stress leave. I think this will be a big part where it will cause employers trouble, is they'll sort of tack it on. Now suddenly we've got a right to disconnect claim as well.
And look, that was one of the things that I thought was the sort of the most concerning about it, is the fact that the people who will make complaints about it will often not necessarily be the ones that maybe need the most protection. And a lot of employers are sort of ignoring the fact that this doesn't actually alleviate their obligation to ensure a safe workplace, and that they don't actually have to wait until someone complains. They should be now looking about, people working from home and people working long hours, and, that they should be looking at fatigue management and not, someone's got a right to disconnect, therefore it's on the employee, not on the employer to actually manage the health and safety. We're going to change gears now and look more at sort of what are the practical implications that you're seeing, and probably the first one. I think you said right at the beginning that sort of one of the key reforms is this putting the unions front and centre, and we've seen in recent media allegations that can at times be open to abuse. And in any event, I guess one of the things that I struggle with is that some of these changes seem to, like the point about always looking to permanent full-time employment, that might be a union policy. But there are many workers who actually want flexible contingent workforce because it suits their way of life and the things that they have going on in their lifestyle. How do you see this playing out in practice, and how do you see, the union involvement in workplaces really impacting on businesses?
So I think that the purpose behind these, especially delegates' rights provisions, is to try and give unions more of a leg up in the workplace, to try and, I don't think necessarily unionise completely non-unionised workplaces, but I think it's often, you sort of talk to some government figures behind the scenes and they'll talk about or people in the union movement, it's always like the lightly unionised, they want to sort of get more of a foothold in. So The delegates' rights process, for instance, has been an interesting one in terms of the issues that pop up from a practical perspective. And I think a key issue with that is, a workplace delegate, they're not a union official. They're a full-time or part-time employee, say, within the workplace that's, getting paid by the employer. And I guess it's kind of this push from the union movement trying to get paid up employees to do more, to undertake more and more work in workplaces that might be, the domain of, say, a union official, helping out with well, not in the workplace, but, potential grievance issues or helping with sexual harassment applications, those sorts of things. So I think a big issue for employers there, for the workplace delegates in particular, will be trying to differentiate between the workplace delegate, or the person as a workplace delegate versus a workplace delegate just as an ordinary employee. And I think there's so many different potential trip points there. So in the legislation itself, we know that there's restrictions there on employers stopping and I'm butchering the wording here, but essentially stopping an employer from hindering the delegate in the performance of their work. There's also not making any sort of false claims, those sorts of points. Then we've also got the workplace delegates' rights term as well, that introduces things like paid time off for training. We've also got reasonable access to facilities, essentially allowing the delegate to almost treat them more as a protected species. And I think a really interesting point here is, well, if you've got a workplace delegate who is ultimately an employee that you have the right to direct as any other employee to undertake their work, they can't
Reasonably and lawfully.
Exactly. I think a lot of concerns that I'm hearing from employers is, well, how if they've got performance issues, how do I manage that? How do I, how can I treat this person as separately to, say, just as an ordinary employee? And I think the answer there is going back to a lot of the advice I'm giving across, the right to disconnect and things like that. It's just setting out clear expectations. So if you've got written clear expectations with that delegate that's looking at, again, because reasonableness is riddled throughout the delegates' rights term, similarly to a lot of other things. What is reasonable?
So you need a workplace delegates policy, effectively.
Absolutely.
So do you think then that the famous IR pendulum has swung too far, and if there's a change of government, we're then going to see it swing rapidly back the other way?
Well, I think in terms of looking back in terms of when the Fair Work Act came out, there's a lot in the union movement, and certainly in labour circles as well, that thought that when Rudd got in and there was then Minister Gillard introduced the Fair Work Act, that they didn't do it, that she didn't go far enough to actually reverse work choices. So I think the speed in which the current Labor government has introduced these laws is very much driven by almost a thought within the Labor movement as a whole that, they didn't act at that time. So they didn't want to repeat the mistake in their view of doing that. So I think that it, to a certain extent, explains the rush and the hurry just to get it all done, what they should have done in, prior to 2007. I think that I'm not going to necessarily say that the Fair Work Act was perfect. I do think that it works as a whole better than what we're looking at now in terms of, there was bits that employers didn't like, there's bits that unions and employees didn't like, but it probably was closer to the middle. It was too complex, but in terms of the pendulum, I think the Fair Work Act as a whole piece of legislation probably got the balance right in most cases. But again, please, not perfect. Certainly the pendulum has swung far too. Not even in favour of employees, and I think that's the key bit here. I think unions are a much bigger winner out of these bits of legislation that the government's passed than, say, employees. And that's certainly true of employees that, those with caring responsibilities, those with studying commitments, those that desire flexibility in their life. Because if you're an employee that likes flexibility, that doesn't want to be stuck in a union job, 9 to 5 type situation, like then you're a big loser in this legislation. So I think that the pendulum certainly has swung away from employers, but I don't think that's necessarily towards employees as a whole. I think it's towards unions and traditional forms of work that really aren't necessarily reflective of our modern day economy.
I think that's right, and I think it's one of the most disappointing parts of it, because I feel like we're sort of gone back in history but ignored the fact that actually the workforce has moved on, people have moved on, and we're not meeting legislation for the current times, and I do think that workers will be the ones, unfortunately, who may end up suffering out of it as businesses move away from it. Do you think there's more change in this government to come?
Well, I think the Minister said, he made some public comments a few months back after this and said, oh, that's it, no more. And then he kind of walked that back and said, which I guess makes sense. You have to be
no more unless you make it. So is that what I read there?
But we certainly saw the demerger laws come through in terms of for the CFMEU.
I thought that comment was a message to the High Court. That was
Yes,
who I thought he was talking to when he was saying.
Yeah, I think so too. I think in terms of, I can't see any major legislation this term, noting that the election has to be called by May of next year. It's not, although they've moved complicated IR legislation in a shorter time period, but in terms of the union wish list, I think most of the things have been ticked off, so it kind of leaves the question.
They've got a bit on their plate at the moment dealing with union wish lists as well.
Exactly. But I think the point, the area to keep an eye on is technology, AI, and potential restrictions on both of those for employers. So currently in Parliament, there's a number of different parliamentary inquiries looking into this exact issue. The ACTU's made some public remarks and has policies in this space as well. So in terms of if you've got, say, policies in place or looking to introduce AI or any sort of technological changes within your workplace to make yourself more productive and to do what most businesses are doing overseas.
And because employment now is so difficult, you need some robots to work instead of the employees.
Exactly. I think there's real union movement to place restrictions on some of those. So I think that will be, again, don't want to be a gambling sort of glazing into the crystal ball, but I think that might be the next industrial relations battle.
So you're talking about sort of just transition sort of policies?
Well, although we've already seen a lot of that, I'm more talking about, so I think the ACTU has a policy in place at the moment where they want us to, they want the ability to include in enterprise agreements, almost needing union consent to introduce technology in the workplace. I would say that a lot of EAs already have that in place. So it was good to hear that the ACTU also thinks they're unenforceable, but they think there might be legislation to be changed there. There's also some unions would like beefed up consultation obligations in terms of, again, if you're introducing AI or other forms of technology in the workplace as well. So things like of that nature, I think, is a place to watch out for.
Well, thanks, Jess. This has been incredibly interesting, and thank you for your time and coming along with us today.
No, thanks for having me.
Thanks very much, Jess. It's been incredible having your insights, particularly as someone who's been at the cutting edge of negotiation around a lot of these reforms, both pre and post the current government. So you've had some great perspectives for our episode today, and thank you very much for joining us. We look forward to our viewers joining us on our next episode of Perspectives on Closing Loopholes with Clayton Utz. We have a really exciting guest who's going to be joining us, a key stakeholder in the area, and we look forward to talking with you then. Thank you very much.